Before we get you back to court, let's bring in National Trial Attorney Michael Jaafar. Michael, always great to have you on with us. Thank you for your time. I mean, this is a case of intrigue, but at the end of the day, we know we have drug users, we have drug sellers, we have the owner of the home then serve time for drug trafficking. These aren't the kind of people that everyone's going to like and say, oh, they're great, upstanding citizens. How much does it affect a jury to start with that premise that the defense made very clear? These are drug users, these are drug dealers, so you need to know that from the beginning.
Oh, absolutely. It's going to affect them dramatically because the sympathy factor by the jury is going to go way down when they know that these people are villains, right? And I'm not saying this is right, but they will kind of not feel sorry for some of them, and they might blame some of them and say, you know, hey, listen, you put yourself in this situation, you reap what you sow. So the answer to your question, Judge Ashley, is it's going to affect the jurors, in my opinion, deeply, and not against the defendant necessarily. It's I mean, they might point the finger somewhat to the victims. I don't think they should, but I think it's going to definitely have a dramatic impact.
You know, Mike, the murders in this case were very brutal. I mean, there were over 40 stab wounds on one. That person was stabbed while they were sleeping. There was what do they call that? Blunt force trauma to the head of another. I mean, these are brutal murders, right? And what we have here, what this jury is going to hear, that there was a lot of anger between this Dean Smorrow character and his girlfriend, Christine, one of the victims. But we're also going to hear that the defendant thought that these guys, or at least one of them, were informing on them to the police regarding this drug enterprise that they had going on, but not with the same amount of vitriol that I see in the murder. So I wonder, normally it's a positive for the state when they have really brutal murders. Here it might be a negative.
Yeah, no, I agree. It's going to be a big negative because at the end of the day, the victims here in this case brought themselves into a situation where they were around these characters, and these characters really are just very bizarre and very dark, and the whole entire thing, the drug use, the text messages, the nature of the crime, the heinousness of the crime. I mean, to stab somebody 40 times, right? Just imagine seeing that on video. Just imagine if you're investigating the crime, right? I mean, what is left of that person's corpse at that point, stabbed 40 times? It's really, really, really bad. So I think this whole thing is becoming grotesque, and the jury are in the courtroom witnessing it, and we haven't even gotten to the defense's case. I'm really interested to see what their case is going to be. I mean, we have a kind of hindsight, foresight into what they're going to do, but this is looking really, really grotesque.
And, you know, Michael, whoever did it took time to then, as you know, wrap the bodies in a tarp and put them underneath the stairs in the home. So they took some additional time to do that.
Yeah, but we do know, and here's the part that complicates things, we do know that the DNA of the defendant was found on bags where DNA of the victims were found.
Yeah.
So we know he had something to do with it, and that's what makes it difficult.
Yeah, it does make it difficult. All right, let's... Welcome back to Court TV Live. I'm Judge Ashley Wilcott.
And I'm Michael Ayala. We want to turn now to the killer or cover-up murder case going on in Massachusetts. Today, defendant Karen Reed was back in court where attorneys argued a motion by the defense alleging discovery violations.
Reed is accused of running over her boyfriend, Boston officer John O'Keefe, and then leaving him to die in the snow outside of a home in January of 2022, very cold month after a night of partying. The defense is seeking phone records belonging to law enforcement officers Brian Albert, Kenneth Berkowitz, and Brian Higgins.
The defense contends they participated in a cover-up directly or indirectly, but attorneys for the officers are pushing back.
And it wasn't just text messages between them. After first testifying that he didn't want to talk to Kevin Albert about the investigation, Brian Higgins later admitted that before he testified before the federal grand jury on June 1st of 2023, Higgins and Kevin Albert talked on the phone for a good 15 minutes. That was 2 days before he testified before the federal grand jury. Before he testifies to the feds, Brian Higgins is conferring with Kevin Albert, who's supposedly conflicted out of the case. So, you know, my goodness, with all the allegations of witness intimidation thrown around by this DA's office and special prosecutors they appoint, why has Kevin Albert never been investigated for witness intimidation? And for that matter, why has Brian Albert never been investigated? We need this evidence, these phone records, in admissible form. That's why we're filing this Rule 17 motion. We have more than met the requirements of Lampron. The records are relevant because they tend to show a cover-up. They are relevant because they show a Canton police officer inserting himself into a case in which his department was conflicted out precisely because he was an officer there. They're relevant because they impeach the credibility of Commonwealth witnesses who deny that they are a part of a conspiracy, yet the phone records tend to show they were conspiring together.
Brian Albert does not object to turning over the materials that are being requested. I understand that the Commonwealth may be having objections as to the Commonwealth's case, but Brian Albert does not have anything to hide. He does not have anything that he needs to prevent the court from seeing this material. And if the court does deem, after reviewing the material and having access to the federal records, that these are somehow relevant or that these are somehow admissible, and the court deems that Rule 17 has been satisfied, Brian Albert will comply with the court order.
Brian Higgins has not participated in any kind of a cover-up or conspiracy to cover up the criminal activity of others. Brian has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a congressional medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq. Participating in a cover-up is contrary to who he is as a human being and a professional. I am here to represent Brian's interest in privacy. Brian Higgins, at my urging, will not capitulate and stand down when efforts are made to further intrude upon his privacy based upon sheer speculation. It is for that reason that we oppose these motions, not because Brian Higgins has done something wrong or has anything to hide.
All right, the judge ended up not ruling on the motion today. Reed will be back in court March 26th for another pre-trial motions hearing. All right, joining us to discuss still, National Trial Attorney Michael Jaafar. Michael, I got to get your thoughts on this one. You heard Brian Albert's attorney say something that I think makes a lot of sense. Look, he did nothing wrong. You want the records? We'll turn them over. Why wouldn't everyone just be saying that? That's a question a lot of people have.
You know what? Those guys were very, very, very cavalier. They basically said, our client is a Boy Scout. He got a congressional medal. He served his country. He was a firefighter before he was an ATF agent. It was refreshing to hear, because I'm really closely following this Karen Reed case. I've told multiple people, I've said it on Court TV, I've said it to my friends, this is fascinating. This is documentary material. People in Boston have a unique mistrust for their institutions. And so they've leveled these accusations that this guy was part of the cover-up, and his attorneys come in and say, he's a Boy Scout. He'll cooperate. So I'm really fascinated to see how this thing turns out. To answer your question is, yeah, I wish everybody would say that. By the way, it would have been a really bad look if his attorney stood up and said, Rule 17 has not been met. We don't want to turn these over. Or, oh, by the way, by total coincidence, we lost these records. Total coincidence. They were just deleted. No, we're sorry. Promise not to do it again, right? Had that happened, it would have just fed into the narrative that Karen Reed is propagating. But them coming out and saying that kind of takes away some of the steam of the Karen Reed, narrative.
I agree 100%, but the truth is, we have heard that before, Judge.
Yes.
Where stuff gets lost, stuff suddenly can't be found or was deleted somehow. So we've heard those things.
Yeah.
Not here, though.
The best that the defense attorney argued in this case to me was when he had been told that one of the guys butt dialed, and then he said, yes, but we now know that he couldn't have answered with his butt, and there was an answer. So some of these things seem a little, right? When you hear them, you're a little suspicious, but that mistrust, I think that mistrust that you just described of Boston police is heightened by this entire hearing, and the fact that some of them are not saying, we'll turn this over. Yeah. We'll cooperate, Judge, if there's an order, of course. But in the meantime, it's privacy. Privacy, they need to protect this information. Well, I guess my point, though, is privacy is one thing, but if these are relevant to the defense or to the case in chief, and I don't think it's necessarily prejudicial. I think that the probative value means this stuff should come in, Michael.
I think it's deeply relevant, Judge Ashley, because at the end of the day, they have staked their claim on this. The trial hasn't even started. We're still in pre-trial hearings, right? Their whole entire defense is that she's being framed. Well, so it's deeply relevant to see that the police officers that she's accusing of framing her conspired behind her back. It's deeply relevant. They're going to get admitted. And so at the end of the day, the mistrust that exists in the Boston area is unique. I'm not saying it's justified. I'm not saying it's not justified. I'm saying it's unique. If you ask anyone in the country, do you think that your local police department is corrupt? They'd be wrong. They'd say, oh, yeah, generally speaking, there's corruption. People would say that generally speaking. In Boston, it's different. It's the worst I've ever seen or witnessed or experienced. And so in this specific situation, it doesn't even have to be Karen Reed. You could insert any defendant. If they just hurl the accusation that they're being framed, you're going to see riots outside of that courthouse. There was a protester indicted for witness tampering here in Boston on this case. So it's unique, and so it's relevant. They're going to go in. They're going to get admitted.
Yeah, but Judge, you're a former judge, obviously, and you know the court has a vested interest in not allowing fishing expeditions by the defense because that stretches out the trial. It invades privacy. So talk to me a little bit about that.
I think in this case, and you and I have talked about this, the fact that there's a federal investigation that gave information that I think then set some parameters so it wasn't a fishing expedition anymore. It's based on what that investigation found that they now have some evidence to suggest they're not fishing.
Yeah, it raises questions.
Absolutely, it does. It does. All right, coming up next, we're going to switch gears. We're going to take a break.
All right, there are new developments in the Baldwin movie shooting case. Court TV has obtained a newly unsealed court document where the defense claims that prosecutors once offered Alec Baldwin a plea deal.
Here's part of what was filed in the motion. On October 5th, 2023, 6 months after dismissing its case against Baldwin, the state informed Baldwin's counsel that it was offering Baldwin a plea deal. A plea to the petty misdemeanor identical to that accepted by Dave Halls. Now, 10 days before that deadline, the special prosecutors abruptly reversed course and informed Baldwin's counsel that they would proceed to a grand jury.
Prosecutors didn't acknowledge the alleged offer in their response to the motion, and Baldwin is charged with involuntary manslaughter in the 2021 death of cinematographer Helena Hutchins on the set of Russ. Now, here's part of his police interview about the shooting.
I was supposed to have an empty gun.
Empty?
Or when we shot, for the rehearsal, empty. And then when we shot, the flash rounds and everybody preps. And then she says, hot gun. She announces it and the crew gets ready.
But you didn't even get to that part.
I rehearsed with a hot gun. Now.
But you were supposed to be cold.
Well, it was supposed to be cold or empty. But now, not only did I rehearse with a hot gun, I rehearsed with a gun that had a bullet inside. If that's what came out of your show, this is the most horrifying thing I've ever heard in my life.
Well, so yeah, and that's why I wanted to make sure that anytime that you shot a hot gun, you've never seen anything like this come out before.
Never.
Because I'm not familiar with prop guns. I can tell you what a projectile looks like, and that does look like a projectile.
But see, that's a bullet.
But yeah, so that's what comes out of.
Well, I think the question, I mean, I don't really want to tell you your job, but I'm so sick about this, so sickened by this, that a bullet passed through this girl's body. She's in critical condition in the hospital right now, and I fired the gun. And if you don't think I feel really about that, I do, but the question becomes, if you ask Hannah, did you commingle live bullets? What they call live rounds. When they say live rounds, that's a bullet that a police officer would shoot. Where did that come from? In her kit?
Yeah.
She commingled live rounds with dummy rounds or movie rounds.
Well, and we asked her that. Do you know where you guys get the rounds from? Who orders it? Or you don't have any part of any of that?
Who, me?
Yeah,
that's her. Yeah.
All familiar. Okay.
All I know is when we come to the set, you hand me a cold gun. Nothing's in it. We rehearse. Then we load the gun with the flash rounds and we shoot. That's it. Every time. We've never had a problem.
So you didn't even get to that second part of you'll hand it back. I do want to ask you about Dave Hall. I understand sometimes she'll hand the gun off to Dave Halls and then he'll hand it to you. Did that happen at this incident?
I don't recall ever doing it.
It was Hannah handing.
I never recall. I recall that when we would stop the scene, If we finish the scene, Halls is someone who is assumed by his position to be authorized to do nearly everything. So if I was doing a scene with you and we finished the scene, or we finished your angle and we were going to turn around and shoot my angle, when they say turning around, that means it's time to go to the bathroom, go get a bottle of water, go get a coffee, go smoke a cigarette. We have a break. And if I was going to go to the bathroom, I'd hand Halls the gun to give to her. I would only hand it to her, or if she wasn't around, if she was away because she'd be at the shop, they cleared it. They hand Halls the gun, they give it to her. Give this to Hannah.
So sometimes you would hand the gun to Halls, but you never, he never handed the gun to you.
No.
Okay.
No, never.
So you would hand it to him.
I'd pass it off to him if she was not on site, and I was going to run to use the bathroom. I was going to buy it. But that's very typical. Halls is empowered and authorized to hand him the weapon. He's the only other person to hand the weapon after we were done. Whether it was a cold gun with no things or flash rounds, I'd say hot gun, hand it to him. Well, usually not, because usually it was a hot gun. If it was a hot gun, we were going to shoot. She'd be right nearby. Okay. If I hit, because other times we have rubber guns. We have fake guns. Yeah.
And specifically, right before this incident, Hannah handed you the gun and said cold. It wasn't David.
I don't be cold. No, Hannah handed me the gun.
Okay. It wasn't anybody else but Hannah.
No, Hannah handed me the gun.
And she specifically said.
I believe she said cold.
I just want to point out, Judge, that he seemed to not be 100% honest. He said there were no problems on the set. Just the day before, we know from the trial that the camera folks had walked off because of problems on the set. He had to have known.
Right, and I said, well, did he necessarily know? But also, producer pointed out that Hannah Gutierrez said he was told about the problems as well. So, to your point, I think he well knew what was going on that set.
Yeah, now Baldwin is scheduled to go on trial on July 9th, of course.
The film's armorer, Hannah Gutierrez, was found guilty earlier this month of involuntary manslaughter. Her attorneys have filed a motion for a new trial, and her sentencing scheduled for next month will now be a motions hearing to hear this new request. Joining us now, still with us, Michael Jaafar. All right, Michael, a lot to digest about this case, but I have to ask you this. Do you think it's possible, because I do, that had Alec Baldwin stopped talking to the press and insisting he didn't pull the trigger and all these different statements he made, had he just kept quiet, do you think that perhaps a plea deal might still be on the table for Alec Baldwin?
I think so, because in that interview, he kind of shot himself in the foot, no pun intended. He said that at the beginning of this, I shot a live gun, and he actually said, I shot. Whereas the theory of their defense is he did not squeeze the trigger, he held the gun and it malfunctioned. They got lucky, obviously, that the gun was broken during testing. So I think he should have shut his mouth. And when I was watching that video, that interview, I kept thinking about how great of an actor Alec Baldwin is. He's just such a great actor, and you just don't know. It's not fair to him, kind of. You don't know if you're seeing acting or if you're seeing genuine stuff. He tried to cry, or maybe he did cry. Maybe it was genuine, maybe it wasn't. But you have to think about that stuff. If I was in that police interview and I was putting on that type of a show, I'm not a trained actor, that would look genuine, but you just don't know. But I think had he just shut his mouth, and I don't know why he didn't shut his mouth. And by the way, the petty misdemeanor they offered him, he should have absolutely taken that. I mean, you should have taken that within 24 hours of being offered it.
Yeah,
so,
that's what I think, too. I think immediately.
All right, well, we don't know the terms. We know that Hannah Gutierrez was offered a plea deal.
Yes.
But they wanted her to admit that she brought the live round on the set. We don't know if they attached something to this deal saying, oh, admit that you pulled the trigger or something along that line. That would have been something you could have, maybe dealt with, but I don't think he would have agreed to that. So we don't know. And here's what changed, Michael. They offered it on October 5th. October 17th, that's when they got the report back that the trigger, at least according to the test, the trigger had to have been pulled. So they know that he, or at least they think that he lied to them. I think that's why they pulled it. And just to be clear, that's not an offer's not binding, right? You can make the offer and rescind it at any time.
Yeah, no, I mean, they did the right thing by rescinding the offer, and I'll tell you why. When they pressed the charges the second time, I thought that the charges made sense because he was the executive producer. He's in charge. He's the boss. Everybody works for him. And again, they did not charge him with premeditated murder. They charged him with a very low bar negligent crime, involuntary manslaughter, right? So I think had he just taken the deal, it wouldn't have been binding. But at the end of the day, I think they would have gotten the political gloat from saying, look, he pled guilty. We did not take a no contest plea. He pled guilty. He did an allocution, and then we can bury this chapter. Because even now, I mean, what are the sentencing guidelines if he's convicted eventually, right? He's still going to do probation. I don't think you'll see the inside of a jail cell, but I think he should have taken that deal if he could have.
All right. Thank you. We're out of time, unfortunately. Always appreciate Michael Jaafar being with us. Michael, tell us about your show, please,
All
sir.
right, have a fantastic afternoon. Always a pleasure. Folks, stick around. Much more ahead in our next hour. Court TV's Kelly Craft joins us with an update on the case against Karen Reed. Plus, we bring you new developments in the election interference case against former President Donald Trump. And we hear key testimony in the small town secrets murder case. A law enforcement witness testifies about their investigation and a possible alternate suspect. Keep it here on Court TV.